Welcome to this video. Today's topic, drafting your own Sharia compliant will. Therefore, if you are a Muslim and you want to draft your own will, you should ensure that it is Sharia compliant. In other words, what is stated in your will is in terms of Sharia law. For example, should you pass away, Islamic law describes what your heirs should receive, and you cannot draft a will stipulating that an heir who should receive X in terms of Sharia law should receive something else. For example, if you have a son and he should receive X portion of your estate, you cannot draft a will and say that your son should receive more or less than what Sharia law prescribes. Therefore, if you are a Muslim, you should ensure that before you pass away, that you execute a will where you specifically state that Sharia law should apply. If you do not do that, or you pass away without a will, the South African law of intestate succession would apply, and your estate would be one in terms of South African law, which is not in terms of Sharia. That's very important to note. Before you see a template, a Sharia will template. On top, there are the words Sharia will, last testament. There is an introduction, and you'll start off with providing your details. Please note, you can download this will by following this link in front of your screen, and I will come back to that link a bit later on. Before, you have to identify yourself, who you are, an adult, male or female, being of sound mind, hereby declare this to be my last will and testament and state the following. I hereby cancel, revoke, and annul all previous wills, codicils, or other testamentary writings or bequeaths made or executed by me. Therefore, should there be another will somewhere that you previously drafted, automatically that will falls away. And you record the following. I am a Muslim and subscribe to the principles of Islam. Therefore, at my death, it is of utmost importance that my entire estate be wound up, distributed, and administered as provided for in terms of Islamic law. That's very important because you do not want your estate to be wound up in terms of a different law. You make it clear, therefore, whatever Islam says should take place at my death regarding my estate, be it monies, assets, zakah, religious or otherwise, etc. Can you provide further details that how Islamic law should be applied to your estate should you pass away? Now, before you, these are general clauses with the intention of taking any doubt away that Sharia law should apply. Now, before us, we have the first page. At the bottom of the first page, the signature of you, the testator or testatrix, should be written, as well as that of the witnesses. And now we're moving to the second page. The same applies here. Should you be married, you can insert your spouse's details and your children's details as well. It's a very good idea to do so. And at the same time, you should nominate and appoint an executor or executrix to your estate at your death. This will be the person that would be administering the winding up of your estate, obviously under the purview of the Master of the High Court. You nominate someone, and at the same time, you stipulate again, I hereby direct that my entire estate be distributed according to the Islamic laws of inheritance as outlined above. You are allowed to make a bequeath to a non-heir. It should not be more than a third. Please, when you are doing this, consult with a religious scholar to confirm whether or not your bequeath is in terms of Sharia law. And point 6, you say the bequeath is subject to it being allowed in terms of the Islamic laws of inheritance as stated. Now, we put this clause. Point 7. If at the time of my death it is found that any specific bequeath is not in accordance with Islamic law of inheritance, then I request that the specific bequeath not be given any force and effect, and as if not written herein. So you are making sure that when you pass away, Sharia law is applied. Now, how do we determine at your death who should receive what? If you are married, if you have children, males or females, who gets what? What are the proportions? You do not stipulate that in your will, because today, when you're drafting the will, you may be unmarried, no children, but when you pass away, there are children. You have a spouse. Or something else might happen. When you draft this will, you have a spouse and you have X amount of children. But when you pass away, you no longer have a spouse or one of your children has passed on. Whatever the facts are, the circumstances are different. Therefore, in this will, you stipulate that you nominate a third party, a Sharia expert, someone who understands Sharia law and the laws of inheritance. That specific party would, at your death, provide a certificate to the master saying, this individual passed away with a spouse, with 2 daughters and 2 sons. Therefore, in terms of Islamic law, these are the portions each of these specific persons should receive. Because had you have placed those specific portions in your will when you drafted it, and circumstances would have changed later on when you pass away, then everything would change in your will because those allocations in your will are no longer valid. Therefore, to avoid any problems, you appoint a third party. Clause 8, you say, I nominate the Sheikh Maulana Islamic Organization to be charged with the task of issuing a certificate to be presented to the Master of the High Court or relevant authority in affidavit form, which shall set out, amongst other things, the full names, ages, and addresses of my lawful heirs at the time of my death and their respective shares, as prescribed for in Islamic law, and whatever other relevant information to give effect to all of the above clauses, and shall be accepted by the Master of the High Court or relevant authority for the purpose of distributing my estate in accordance with the said Islamic laws. Then you go further and you say, you direct the executors that, my apologies, I hereby further direct that my executors referred to above shall not be called upon to furnish any security to the Master of the High Court or relevant authority for the full and proper administration of my estate. That is a clause you can insert. Then clause 10, you say you understand this is your last will and testament, and then furthermore, you sign this. Now, it is very important that this document is signed before two witnesses. Just going back to page 2, please note that at the bottom of page 2, you and the witnesses must also sign this document, or at least page 2. On the last page, all these parties must sign, you as testator or testatrix, if you're female, and the witnesses as well. You can see the disclaimer here. Please obtain advice regarding your will should you draft it on your own. Now, regarding the execution, this is how it works. Execution meaning when you sign the will and you're finalizing the will before witnesses. In the presence of two competent witnesses. Now, it's very important that it cannot be little kids. It must be competent people. Therefore, I always advise clients or persons that are drafting the will, make use of adults. People that are 18 years old and older. Therefore, and they must be mentally competent as well. In the presence of two competent witnesses, sign each page of the will at the bottom. So you sign these 3 pages if your will is 3 pages at the bottom. The witnesses must both see you sign. That's very important. Because how can they be called witnesses if they witness nothing? What some people do is they sign the document, they give it to a third party in a different room at a different time to sign as a witness. They witnessed nothing. On the last page, the signature would be at the place provided. That makes sense. You do not sign twice on the last page. If the last page has your name, you sign there. Then each witness must sign each page of the will in your presence, also at the bottom, the same as you have done. Exactly. You need to see the witnesses now signing where you signed or where the name is on the last page. Here it is. On the last page, the signature would be at the spaces provided. They may also write in their names in the spaces provided at the end of the will. Very important, please ensure that the witnesses are adults and are persons who would not inherit in terms of the will. That is very important. Your witnesses must be persons that will not inherit. Therefore, do not use your parents, your siblings, your children, your spouse, and so on as persons, as witnesses in your will, because they can inherit from you. Use non-family members as witness. Very important. Once the will is signed, keep it in a safe place. You are welcome to email it to us. That's something else. If we drafted your will, we'll send this document to you, and you can send it to us or to the religious leader to verify that the will is correctly executed. Here is a link again. The document that was shown earlier on, the template, with the instructions on the left. That document can be downloaded by using this link. The document that's in front of you now. Therefore, in summary, you draft the will, you provide your details, you say Islamic law applies, you cancel all previous wills, you mention a wasiya, a gift, a third to a non-heir, and you mention who the executor is, you mention who the organization is that provides the certificate, and you sign the will in front of two witnesses. That's the long and the short of it. Otherwise, I wish you all the best and have a lovely day further.